Good afternoon and welcome to the City Club of Cleveland. My name is Paul Harris and I am president of the City Club's Board of Directors. I am very pleased to introduce today's speaker, Stephen Wermiel, Fellow in Law and Government and Associate Director of the Summer Institute on Law and Government at American University Washington College of Law. For nearly 100 years, the City Club of Cleveland has fostered the free expression of ideas and the benefits of an open exchange. Frequently, like today, the City Club welcomes renowned scholars to its podium to address matters that are certainly of intellectual interest, but also are relevant to and have significant implications for everyday life in our great American democracy. So today we welcome a scholar whose areas of expertise include constitutional law and the First Amendment, and who has devoted much of his professional career to explaining the intricacies of the highest court in the land to students and to the general public. Professor Wermiel obtained his undergraduate degree from Tufts University and thereafter served as a reporter in Boston and Washington, D.C. for the Boston Globe. He obtained his law degree from American University Washington College of Law. From 1979 to 1991, he served as a Wall Street Journal Supreme Court reporter, covering and interpreting more than 1,300 Supreme Court decisions. In addition to teaching constitutional law, First Amendment, media law, and a seminar on the workings of the Supreme Court, Professor Wermiel is involved with the Marshall Brennan Constitutional Literacy Project, a program in which American University Washington College of Law students teach constitutional law in the public high schools of Washington, D.C. Professor Wermiel previously served as Associate Director for that project. He is a frequent commentator on Supreme Court developments, and his extensive publications include numerous law review essays on Justice Brennan, as well as co-authorship of the book Justice Brennan, Liberal Champion. He previously served on the Board of Directors and Legal Committee of the American Civil Liberties Union of Georgia. Professor Wermiel currently serves as chairman of the editorial board of Human Rights, the magazine of the American Bar Association's Individual Rights and Responsibilities section, whose First Amendment committee he co-chairs, and as a member of the editorial board of Communications Lawyer, the journal of the ABA's Forum on Communications Law. I am very pleased to present on behalf of the City Club of Cleveland, Stephen Wermiel, Fellow in Law and Government and Associate Director of the Summer Institute on Law and Government at American University Washington College of Law. That's a lot of words there.
Thank you, Paul. Thanks for the nice introduction, and it's an honor to be here, not just because of your 100-year tradition, but because Justice Brennan, whose biography I wrote and about whom I want to talk to you today, really was probably the most ardent champion on the Supreme Court of robust debate, of open exchange of ideas. And so the tradition of the City Club, I think, is a wonderful one, and I'm proud to be able to carry it on. Actually, just as an aside, when I, in preparation for this biography, tried to determine from Justice Brennan what were some of the influences that made him who he was, one of the things he talked about was a lecture series, not exactly like the City Club, but I think that carries the same tradition in Boston when Justice Brennan was at Harvard Law School. There's a lecture series called the Ford Hall Forum, which has gone on for many, many years in Boston and brings speakers of all views and ideas and so on together. And so he felt that that actually helped shape him and influence him. So it fits nicely with the story that I'd like to tell you today. The book that I co-authored, Justice Brennan, Liberal Champion, is a biography of a man that we describe as perhaps the most influential justice of the 20th century on the U.S. Supreme Court. Now, that's a debatable point, and I'm happy to have that debate later in the question and answer session if people want to, but I'd like to tell you a little bit about why I think he was so influential. Justice Brennan was on the Supreme Court from 1956 to 1990, a period of 34 years. And just for sort of timeline and historical perspective to refresh your memories, When he came on the court in 1956, that was the court under Chief Justice Earl Warren. It was 2 years after the school desegregation decision, Brown versus Board of Education. And so he served on the Warren court until its end in 1969. He then served under Chief Justice Warren Burger, the Burger Court, from 1969 to 1986. And then on the Rehnquist Court, the first few years of the Rehnquist Court, from 1986 to 1990. So that's the period, but rather remarkable if you think about all of the things that happened in our history and how our country changed during that period. And I'd like to suggest to you that Justice Brennan played a pivotal role on the court. Now, what is interesting about that is that if you looked at Justice Brennan during much of that period, if you tried to explore Justice Brennan in magazines, newspapers, published works from 1956 to about 1980, so the first 24 years of his 34 years, it would be very hard to find out anything about him. He was, as we say today, under the radar. He was not a highly visible figure. He was surrounded, particularly in the Warren Court, by people that the legal establishment thought of as intellectual giants. Hugo Black, William O. Douglas, Felix Frankfurter, Robert Jackson, John Harlan. Right? Those were the justices of the 50s and 60s who we considered to be really the giants of Supreme Court theory, the giants of intellectual theory. And nobody ever put Brennan on that list. But I would suggest to you that what Brennan was the best lawyer of that whole group. And that contributed significantly to the influence that he had. Now, what is the influence that I'm talking about? Even today, and he left the court in 1990, he died in 1997, so this really is becoming history that we're talking about here. But even today, Brennan's influence is significant in free speech, in separation of church and state, in other aspects of freedom of religion, in the debate over the death penalty, in the debate over affirmative action, in the controversies surrounding abortion, in the debate over the role of the Supreme Court and how to interpret the Constitution. Brennan's view is one of the central views in the spectrum in that debate. There are very few things that you could name that are important aspects of our constitutional understanding in which Brennan's influence isn't still felt today in our society and isn't still a focal point for today's Supreme Court. Sometimes to dramatically disagree with Brennan's view, but nevertheless it's Brennan's view that they're focusing on. So how did this happen? How did we know so little about this individual who was so influential? That's really the story I'd like to tell you a little bit about today. Justice Brennan was born in Newark. He was the son of immigrant parents. His mother and father immigrated separately from Ireland and would never have met, even though they only lived a few miles apart in Ireland. They lived in small villages, and really there would have never been any mingling of the populations of those villages. They met in New Jersey, married. Justice Brennan was a product of that marriage. His father was a fascinating figure. His father worked his way up from being a coal shoveler, what they called a stationary fireman, a coal shoveler at the Ballantine Brewery in New Jersey. His father worked his way up to become a labor leader, and then because of populist issues about labor in the city of Newark, his father ran for the city commission, finished second in a citywide election, and the way it worked in those days is the person who finished first became mayor. The person who finished second could choose what responsibilities he wanted. So Brennan's father became police commissioner and fire commissioner in the city of Newark. wildly popular public official. When he died in 1930, he lay in state at the Newark City Hall. Tens of thousands of people filed past his casket. The donations of flowers occupied a huge amount of space. A very populist individual. Not a civil libertarian. If we want to talk about where Brennan's progressive values came from, he didn't learn about civil liberties from his father. What he learned about was respect for the individual, respect for everybody, the sense of human dignity that his father cared about. His father believed in treating everybody fairly. He was not a First Amendment advocate. He was not an advocate of separation of church and state the way Justice Brennan became. But his father believed in treating everybody fairly and that everybody ought to have opportunity. And I think that influenced Brennan very significantly. His father died while he was in Harvard Law School. Brennan came back after graduating and enjoyed what he would describe as a series of, and pardon the directness of the term, but a series of Catholic firsts, if I may describe them that way. He joined a Newark, New Jersey law firm that had never hired a non-Protestant in its history. Brennan became the first Catholic in the firm and was kind of proud of his form of integration, if you will. As he rose through the ranks to prominence in New Jersey legal circles, there were other similar examples. He was very proud of being the first Catholic at a New Jersey Shore beach club some years later. And then when he went to the Supreme Court, he occupied what was then the Catholic seat on the Supreme Court. A remarkable thing to contemplate when we now have a Supreme Court with 6 Catholics on it. But Justice Brennan in 1956 was the Catholic seat on the court. He was very involved in labor law as it was developing in the 1930s and 1940s. And the law firm took great pleasure, I think, in sort of exploiting his background, right? The Harvard Law School son of a union leader was representing management, the corporate side, in labor relations for this Newark establishment law firm. And as I said, the law firm, I think, took great pleasure in the irony of that. I'm not sure Brennan appreciated the irony of it quite as much, and after a while it sort of wore on him, and he participated in rewriting the New Jersey Constitution in 1947, and then was persuaded to go on the New Jersey courts, first as a trial judge, then as an appellate judge, and finally a New Jersey Supreme Court justice. How did he become a United States Supreme Court justice? From that background, you might reasonably conclude that he probably was not well known outside of New Jersey. If you reach that conclusion, you're right. It was a fluke and a very interesting story, particularly apropos of today's Supreme Court nomination process. Justice Brennan's nomination, I like to tell people, was one of the most political in the history of the country. Everybody says, really? You mean compared to today's process, it was one of the most political we've ever had? How could that be? Well, here's how it could be. It had absolutely nothing whatsoever to do with the politics of the Supreme Court. What it was about was Dwight Eisenhower had been elected in 1952 with a significant amount of support from independent voters and blue-collar Democrats in the Northeast, who tended to be Irish and Catholic. In 1955, remember, Eisenhower had a stroke. He was in somewhat weakened condition. He was never really in any danger of losing to Adlai Stevenson in 1956, but the White House wanted him to not just win, they wanted him to win by at least the same margin as he'd won in 1952, to show that he still had the support of the people and was not weakened by his health problems. A little-known United States Senator by the name of John F. Kennedy was campaigning to become vice president in 1956, didn't get the nomination, but set his sights on running for president in 1960, and so he was going all over the Northeast United States campaigning for the Democratic ticket. All right, and that's exactly the voting population that Eisenhower was worried would abandon him in the 56 election. So what'd they do? When they got a vacancy on the Supreme Court, they said, even though Eisenhower's a Republican, let's pick a Democrat for this seat. Let's pick an Irish Catholic for this seat from the Northeast United States. So it was the most political nomination in history. It was all about trying to make sure that Eisenhower got reelected by a wide margin. But let me try this out on you. 1956, 2 years after Brown versus Board of Education. Can you think of anything you might have wanted to ask the nominee before you chose him? Right? It wouldn't be hard to come up with a couple of questions that you might want to discuss with him substantively. They didn't ask him anything. They picked him because of his effect on the election, pure and simple. They weren't in the least bit focused about what his impact on the Supreme Court would be. When they took him into the White House press room to announce it, Eisenhower was going to wait until a Monday morning. He met with Brennan on a Saturday morning, and Eisenhower was then going to wait until Monday morning to announce it, but he decided it might leak out, and so he called Brennan back in and said, let's go do it now. Let's go into the press room right now. They had so little preparation time, but were so focused on the politics of it that they went into the White House press room, and the press secretary said to the reporters on Saturday morning, I have the pleasure of introducing William J. Brennan of the New Jersey Supreme Court, President Eisenhower's nominee for the United States Supreme Court vacancy, and a member in good standing of the Holy Name Society. That's it. That's all they said about him, right? Make sure you get in your news stories that he's a Catholic from the Northeast United States. That's what we care about. So that's how Brennan, now that would not suggest to you that we were talking about somebody who I argue became the greatest justice of the 20th century. Not a particularly auspicious start. So how did that happen? Two things, I think, contribute to Brennan's greatness. The first is that over time, I don't think he came to the court with this, but over time, he developed a profound sense of what he thought the Constitution meant in our system. He believed, and I used the phrase earlier, that the Constitution was about protecting the human dignity of all people, and that was the way it had to be understood and read, and other theories that took you in a different direction were wrong. He said very profoundly and very adamantly that in the process of doing that, it was folly to try to interpret the Constitution literally in the way it would have been understood by the people who wrote it in 1787. He said he couldn't do that. He had to interpret the Constitution in the only way that he was physically and mentally able to do as a 20th century individual looking at what the words mean to us in the 20th century, and that he couldn't pretend to fathom or decide what they meant in 1787. Now, he put that vision out there for 30-plus years. Justices with different views came and went. Brennan was still there, consistently articulating this view and deciding cases on the basis of this view. That in and of itself, the long period of time with a consistent vision, contributed significantly, I think, to his influence. But that's not the only part of the story. The second part of the story, which is also unique to Brennan, and this is a story about the way the Supreme Court works, and I'll try to keep it simple and sort of straightforward. But Brennan, almost as much as he cared about that constitutional vision, cared about winning, cared about getting 4 other justices to agree with him. Now, you might think to yourself, well, gee, doesn't everybody do that? If you're assigned to write the majority opinion, don't you try to win? Sure, you do. But different justices will go to different lengths to do that. And Brennan made an art form out of the length to which he would go to accommodate the concerns of other justices in order to get 5 votes and to win. And as an example, there are justices who won't do that. William O. Douglas, who was a brilliant man, was famous for scribbling out his view on a legal pad and sending it around to the other justices, and if they didn't agree with him, they were idiots. He obviously was right, and they obviously were wrong, and that was the end of the matter, but he wasn't going to do anything about it. If they didn't agree with him, it was their loss. He wasn't going to spend a lot of time negotiating and arguing to try to persuade people. In today's court, just a few months ago, Justice Scalia gave a speech, or actually was interviewed in a question and answer session at a convention in Washington, and he was asked, was he disappointed that he'd never had the chance to become Chief Justice? And his answer was no, he wasn't disappointed, because if he'd become Chief Justice, he would have felt compelled to compromise, and he didn't believe in compromising. So not all justices are willing to take the steps that one has to take to make sure that they get 5 votes. Brennan's view, on the other hand, was if I'm putting this constitutional vision out there in case after case and nobody's agreeing with me, I'm not accomplishing anything. Makes me feel good. I like that I have this vision, but I'm not persuading anybody. I need to take the steps that are necessary to persuade. So it really is both of those pieces. It's the vision and the remarkable focus on 5 votes that I think made him so influential. Now, how did he do that? Unlike some other justices who would tell their law clerks, each justice nowadays has 4 law clerks working for them. In Brennan's period, it was first 2 and then 3 and then 4. Some justices will tell their law clerks what goes on inside this office, in this chambers, is absolutely confidential. You may not discuss it even with anybody else in the building, let alone outside the Supreme Court. You can't talk to other justices and their clerks about what we're thinking about and about what we're doing. Brennan was exactly the opposite of that. When Brennan found out that he was going to write a decision and that it was a close decision, 5-4 or 6-3, and he was assigned to write the opinion, the first thing he would do would be to send his law clerks to meet with the law clerks of the other justice who was the swing vote or the most up in the air vote, and say, okay, what's it going to take? What's your justice concerned about? Now, you know, many of you are lawyers and know this. Some of you are not. You know, the Supreme Court, when the Supreme Court decides a case, often the Supreme Court is creating a test or you know, some new 2-part rule or 3-part rule. To Brennan, that was what this was all about. We're going to go negotiate with the 5th vote over the rule. And if the 5th vote says, well, I don't think the 3-part rule really works or it's too strict, but I could live with parts 1 and 2, gone. Part 3 is out of there in a minute. If this would help achieve the protection of some right or constitutional interest that Brennan felt needed to be protected from looking at the cases and looking at what he was seeing, then he'd give up part of that test in a second in order to get the 5th vote, because it was that important. Again, without that 5th vote, you weren't accomplishing anything. So a classic example would be this. For much of his tenure in the 1970s and into the mid-1980s, the swing vote, we now think of the swing vote on the current court as Anthony Kennedy, right? In a 5-4 decision, it's likely that which way it came out is the way that Anthony Kennedy decided to go. For much of Brennan's tenure, the swing vote was Lewis Powell, a wonderful Southern gentleman from Richmond, Virginia, very chivalrous, courtly, had a very nice relationship with Brennan. So the classic kind of interplay would be this. Brennan, at conference, when the justices discuss the case, Brennan hears that Powell is on his side, but kind of shaky, not totally committed. A couple of days later, the Chief Justice assigns the opinion to Brennan to write. Brennan sends his clerks to meet with Powell's clerks and says, what are your justices' concerns? How can we accommodate them? Here's what happens. Brennan drafts an opinion, and he sends it around to the other justices, and some of them just write back immediately and say, I'm happy to join your opinion. Justice Powell writes back a letter that says, Dear Bill, I think you've done a wonderful, splendid job with this difficult case, and I'm so delighted with your effort, and I really would be pleased to join it if you could see your way clear to making a couple of small changes. And then it's a 9-page single-spaced letter. Now, most of us in your right minds would look at that and say, this is impossible, when this is never going to happen. How can I possibly accommodate all of his concerns in a 9-page single-spaced letter? Brennan looked at that and said, we're in the game, right? Like a diplomatic negotiation. If the other side isn't even willing to talk to me, there's nothing going on. But in Brennan's view, that 9-page letter from Powell might have been a little daunting, but at least there's something to work on. We've got something to talk about. Without that, we're nowhere. We're finished. We don't get a fifth vote. So Brennan would then set to work figuring out what were the core parts of Powell's concerns and how to accommodate them. And that accounts for many of the progressive, liberal 5-4 decisions of the 1970s and 1980s. That's really how they came about, was Brennan's extraordinary effort to try to accommodate Powell. Let me make a couple of quick last points, and then I think we're going to have lots of time for questions, which I'm looking forward to. One of the most interesting aspects of this story, which I'll just describe quickly and then can fill in a little bit later, is I had been under the impression, and I think anybody that ever paid any attention to Justice Brennan would have said the same thing, that he was a kind of what you see is what you get figure. Liberal guy, liberal justice, liberal decisions, you know, all on one plane, no other dimensions here. Well, it was very interesting in the research to discover that that wasn't really true, that there actually was a private man whose values were in some ways more conservative than the liberal constitutional vision that he believed in. One example of that is abortion. He said in his, I had the opportunity to do 60 hours of recorded interviews with Justice Brennan in his cooperating with this book. In those interviews, he said he really didn't care for abortion. If his daughter had come to him and asked for his advice and she were pregnant, he would have tried to talk her out of having an abortion. He was a serious practicing Catholic. He didn't really believe in abortion. But his constitutional vision about what the Constitution required for the rights of women was different. There really was a separation between his private values and his sense of constitutional imperative. And that was a big surprise to me. Freedom of the press is another example. Justice Brennan was the greatest defender probably in the history of the court of the free press. But when you look at his relations with the press, he really didn't want to have anything to do with reporters. He didn't trust them. He didn't like them. He got mad at things they wrote. He thought they were disrespectful of people's privacy. But his opinions are the most adamant about the need, I mean, exactly what we're doing here at the City Club. His opinions talk about the need for free and open and robust debate as a core value of a democracy. And that free and open and robust debate includes even the right to make mistakes and the right to be wrong. And if we're talking about public officials, those mistakes might harm a public official's reputation, but you don't want the debate to censor itself in such a way that people aren't really saying what they're thinking and saying what they mean. And Brennan thought that was essential to democracy. But over there, he didn't really want them around him, right? Reporters keep their distance, essentially, was his view. Let me give one last example, in some ways the most interesting. Justice Brennan in the 1970s wrote the two most important opinions, probably in the court's history, for the rights of women. Prior to the 1970s, discrimination based on gender was not a constitutional violation. In two opinions in the 1970s, Justice Brennan brought gender discrimination under the equal protection guarantee of the 14th Amendment to the Constitution. When he did that, he'd had about 60 law clerks at that point. He'd never hired a woman. And when some of his former law clerks tried to get him to hire a woman, he said, no, thank you. Now, what's that about? He grew up in an era, through his experience in the legal profession, in which there were no women. In Harvard Law School, when he was there were no women, no faculty members, no students. Practicing law in New Jersey in the 30s and 40s, there were no women. On the bench in New Jersey, there were no women. On the bench, when he went on the bench in the early 50s, there were no women. So his comfort level was old-fashioned. His comfort level was male colleagues, male peers. But he understood enough about the effects and harm of gender discrimination in our society to make that part of his constitutional vision, even though he remained for a time more comfortable being surrounded by male colleagues and male peers. He eventually hired women law clerks and found out that it wasn't so painful and got along fine with them. But again, it's an example of sort of this fascinating dichotomy that there really was a private individual separate from this profound set of constitutional values. So I think with that I will stop, and we'll look forward to your questions.
Today at the City Club of Cleveland, we are listening to a Friday forum featuring Professor Stephen Wermiel of American University Washington College of Law. We'll return to our speaker in a moment for our traditional City Club questions. We'd ask that you start formulating your questions now and that you keep them brief and to the point so that we can get as many questions in as possible during our remaining 25 minutes. Members and guests alike are welcome to attend City Club forums, and we hope that everyone listening will join the City Club in the coming year as we celebrate our 100th anniversary. That celebration will begin in October of this year with a free speech conference and then conclude in October of 2012 with a gala event. So a lot more on that to come. We welcome all of you here and those listening to WCPN 90.3 FM, WCLV, WTAM, or one of the many radio stations across the country. Our television broadcast partner is WVIZ PBS IdeaStream. Television broadcasts of the City Club are made possible by Cleveland State University and PNC, and our live webcast is supported by the University of Akron. We are very pleased to welcome guests at tables today hosted by the law firm Baker & Hostetler. Thank you for joining us today. And today's program is the annual forum on the American justice system, made possible by generous endowment gifts from Robert J. Fay, David I. Sindel, Myron Krotinger, and Paul W. Walter, in memory of Samuel Glassman. Thank you very much for your support. And now we would like to return to our speaker for our traditional City Club question and answer period. We welcome questions from everyone, including guests with us today. Holding the microphone today is City Club Program Director Kerry Miller. First question, please.
Mr. Wermiel, I don't know if you're aware, but in 1937 or 8, Franklin Roosevelt asked his then Attorney General, Robert Jackson, if he wanted to run for governor of New York. This was before the war clouds, so that he could run for president in 1940. And in 1944, there was a very, very close race between Justice William O. Douglas and Harry Truman for the vice presidency. And Roosevelt wrote a note saying he would be glad to run with either one. Robert Hannigan of Missouri, the head of the Democratic Party, had to hide Roosevelt for 2 weeks before the convention so that Douglas couldn't get it. He tried again in '48. But my question is this, and I'm sorry, not too much to do with Justice Brennan. Had Douglas gotten the presidency in 1945, in what direction, in what same or different, do you think the country would have gone?
Hard question. I mean, I knew certainly of Douglas's presidential aspirations. You know, he would have been obviously a very progressive president if he followed Roosevelt and in lieu of Harry Truman. I think maybe the country would have moved in even more progressive a direction, but I don't know, for example, how Douglas would have dealt with the beginnings of the Cold War, the McCarthy era. I know what his views would have been, obviously, we all do, but I don't know how he would have managed those things. I don't, you know, the country, I think, needed to some degree Eisenhower, the war hero, in the 50s to restore some sense of stability and confidence. And I don't, you know, as much as I like Douglas's views about many things, I don't know whether he would have played that role, I think.
Thank you for coming to Cleveland. Could you talk a bit about, in your opinion, what you believe Justice Brennan's most important decisions were?
Sure. He was actually always very reluctant to pick one, and in my interviews with him said that would be like asking me to choose among my children, and I can't do that. But having said that, I think he had some favorites, or others had some favorites in his behalf, and I probably would talk about three, maybe. In 1962, I think it is, Justice Brennan wrote a decision called Baker versus Carr. And until Baker versus Carr, the issue of the size and shape of legislative districts, what we now think of as one person, one vote. Prior to Baker versus Carr, if you filed a lawsuit saying this legislative district is unfair because that one has, you know, more representatives per person than per population than this one does, the Supreme Court would have said that's not an issue we can decide. That's a question to be left to the political process, doesn't have constitutional implications. Thank you very much and see you later. Baker versus Carr basically said that's no longer the case. These cases should come to court. These cases raise issues under the 14th Amendment, and we will decide them. And so it opened up the federal courts to reapportionment lawsuits and voting rights lawsuits in a way that had not been the case for our entire prior history. Most of the nation redistricted either directly as a result of those lawsuits or the effects of the Supreme Court's decisions after that. So now when I'm cheating a little bit, Brennan didn't say that was his most important decision. Earl Warren said that was Brennan's most important decision, which isn't a bad reference, I think. Brennan was certainly very fond of the case that I was referring to earlier, but not by name, called New York Times against Sullivan, which is a 1964 decision that basically said if you are commenting about public officials, you the media or you even in public discourse, if you're commenting about public officials and you make a mistake and you libel them or damage their reputation, you can't be sued for damaging their reputation unless you made that mistake with what's called actual malice. It has to be reckless. It's not enough that it was negligent. It's not enough that it was careless. It has to be almost deliberate. or deliberately negligent, and you have to have made up your mind that you didn't care, essentially, about getting it right. That gave much greater protection to the press. That's the decision in which Brennan talked about the democracy requiring free and open and robust debate, and it sort of built the foundation of his free speech views, that we really have to have a broad array of views and of speech in order to genuinely function in a democracy. The third one I would mention is a much lesser known case, and I think he became convinced of its importance by other people. It's called Goldberg versus Kelly, and it was a 1969 or 70 decision. What Goldberg dealt with was government creating by law different benefit systems: Medicare, Medicaid, Social Security, food stamps, various welfare programs, and so on. When government creates those programs, and so in the law is a definition of who's eligible for those programs. Prior to Goldberg versus Kelly, in many parts of the country, if you were eligible for one of those benefit programs and the government decided they didn't want to give you your benefits anymore, they just decided it. You had no real recourse. Too bad. In Goldberg versus Kelly, Brennan said that once you qualify for one of those programs, the constitutional guarantee of due process protects your interest in that program, so the government can't take those benefits away without affording you some fair procedures. Notice that you're about to be cut off Medicaid or Medicare, a right to a hearing to tell your side of the story, a right to reasons in writing why you're being denied. And that transformed the relationship between government and society in numerous fairly dramatic ways, so that it extended, for example, to public employment. If you're a public employee and you're fired, the government has to give you some degree of due process reasons and a chance for a hearing. They can't just fire you at will with no accountability. So it went from benefits programs to public employment programs. The principle that students in public institutions have to have some right to be told why they're being disciplined derives from that as well, and so on. So Brennan really thought that created a sort of due process revolution, if you will, and that really transformed the relationship, the accountability of government to the citizens, in a sense. So I guess I would nominate those three.
Professor Wermiel, you mentioned the power of persuasion, which Mr. Justice Brennan had with other members of the Supreme Court. Today the court is very definitely divided with the 5-member conservative group and the 4-member liberal group, and the possibility of Justice Kennedy once in a while switching over. If Justice Brennan were on the Supreme Court today, I presume the way you described him, he'd be part of the liberal group. To what extent do you think he would be able to convince any of the 4 members of the conservative group, other than Mr. Kennedy, to join his point of view?
It would be a more daunting task, I think, than the task he faced. He experienced that a little bit at the very end of his tenure. In the late 80s, it got harder and harder for him to find that 5th vote, particularly after Lewis Powell retired in 1987. The 5th vote, if Brennan were going to find one, had to be Sandra Day O'Connor, who was at least more conservative than any other 5th vote Brennan had ever had to look for before. And then even in his last year or two on the bench, Justice Kennedy had joined the court. It would be a very difficult challenge, it would be more or less the same dynamic that the court has now. Justice Brennan would be trying to persuade Justice Kennedy. Because there really isn't, in most instances, there really isn't going to be anybody else from the conservative wing that Justice Brennan would be able to persuade. So I think it would be an uphill battle today.
You talked about the nomination and confirmation process that Justice Brennan went through. In your interviews with him, did you get any sense of what he thought the nomination and confirmation process of Judge Bork was, and not substantively in terms of some of the dynamics of putting together a coalition on the court that you were just talking about, but in terms of what the effects of Judge Bork's process were on the overall process that we still very much live with today?
I was with Justice Brennan during that entire summer and fall during the Bork nomination in 1987. He had a number of different reactions. I mean, apropos of the specific question you asked, I think he was somewhat horrified by the nature of the process. He didn't like the sort of personal attacks on the nominee and the sort of increasingly dig up dirt detailed nature of the nomination process, and I think was very put off by it. He also sort of very interestingly, I don't think he was ever afraid of a nominee. I mean, you might sort of wonder, gee, wouldn't he have been kind of nervous about having Bork join the court because Bork's reputation was so conservative, and how would he work with him? He believed he would work with him fine. He was confident that they would have a dialogue, and at times they would agree, and at other times they wouldn't. Having said all that, he certainly knew that trading Lewis Powell, who really had become his gateway to winning 5-4 decisions for the preceding 15 years, trading Lewis Powell for anybody more conservative, Bork or Anthony Kennedy subsequently, was going to make his task substantially more difficult. But in his last term on the court, I mean, he won next to last term. He won the flag burning decision. He wrote the opinion, joined by Scalia and Kennedy, that burning the flag was a form of protected First Amendment protection. So he really, he never gave up the belief that he was right, and if he was willing to compromise to some degree, he could have others see the merits of his arguments as he would try to listen to theirs.
I would like to address a question about the current court. Some have said it's almost dysfunctional. I want to point to two recent episodes and ask you as examples as to whether that observation may be correct. One was when an oral argument began with, "This case might be moot," whereupon the Chief Justice interrupted and said, "Then why are you here?" and completely threw off the oral argument. And the other was the rather acrimonious dissent that was read from the bench by one of the conservative members of the court. With those two things as recent examples, would you comment on this question about how they're getting along with each other?
Sure, I'm happy to. I don't think the court is dysfunctional. I think that John Roberts is a very able, effective Chief Justice. And that's not a comment on whether I agree with him or not, but just on his ability to run the institution. I think he's a very able Chief Justice. We're in a period in which I think the divisions among the justices are fairly deep-seated on many cases. But this is something, and I'll sort of tie it back to my subject. This is something that Justice Brennan felt very strongly about. It is very easy to look at the institution and see strongly worded dissents and maybe so passionate that one justice feels compelled to read the dissent from the bench and conclude that they must hate each other and not be talking to each other and not functioning as an institution. And it really isn't true. They really function as a collegial body. They understand in a way, in a very profound way, that many people don't outside of Washington and even inside Washington. That tomorrow the same 9 people have to sit down at the same conference table and look at each other across the table and work together, and the day after, and the day after. And so taking it personally or allowing disagreements to become personal feuds is counterproductive. There have been some. I mean, historically there were some feuds. Black and Jackson didn't get along. Douglas and Frankfurter didn't get along so well. In the period that I've paid attention to the court, Brennan arriving in '56 and then my following the court, in my own work in recent years, I don't think those feuds exist. Justices have offended each other. Scalia writes a strong opinion that sometimes is a little personal and offends somebody. I think some of the conservatives think that Justice Sotomayor is a little pointed in some of her questions and comments, but that doesn't make them dysfunctional. They're trying. They can't always agree. They can't always find common ground. Sometimes their disagreements erupt. The conservative reading the dissent from the bench the other day, the person who reads the most dissents from the bench in this court is Justice Ginsburg. So on the other side of the spectrum. So I don't know that that really suggests a dysfunctionality. It's one of the most difficult things, I think, for people to accept about the institution is that they really do get along. They really do function together. Justice Scalia and Justice Ginsburg disagree about as often as humanly possible, but they're very good friends. They go to the opera together. They even perform in the Washington Opera together occasionally and sort of walk-on parts. They've known each other since they were federal appeals court judges together in the late 70s, early 80s. I guess they served together starting in about 1982, and they really are good friends. So, I think there are a lot of disagreements and interesting things to watch. I don't think they're dysfunctional.
Hi, I've got 2 quick questions. One, who was Justice Brennan's closest friend on the Supreme Court? And secondly, could you give an example of how a case changed in this negotiation process that you talked about, where Justice Brennan took into account the opinions of other justices? If you can just give one example, a particular example.
Sure. Closest friend is hard to say. In the Warren Court era, and this in a sense goes back to the last question too, in the Warren Court era, the justices were very good friends, sort of no matter what their views. The person that Brennan probably disagreed with most on the Warren Court was John Harlan, and they were very good friends. Brennan would stay at John Harlan's house in Connecticut in the summer when Brennan was driving up to Cape Cod or heading for Nantucket, and then stop there again on the way back. They would have dinner together in Washington. Brennan really sort of bridled under Felix Frankfurter's attempts to sort of dominate him. Brennan had gone to Harvard Law School. Frankfurter had been one of his professors at Harvard Law School. So when Brennan came to the court, since we're running out of time, the shortest way to say it is Frankfurter assumed he now had 2 votes instead of 1. And Brennan made it very clear to him that he didn't appreciate that and that was not the case. But they lived right across the street from each other in Georgetown and were friends. They'd have dinner together. Brennan's daughter would go entertain Mrs. Frankfurter, who was bedridden, playing the piano for her and so on. There were lots of different friends. He got along well with John Harlan. He and Thurgood Marshall were were friends, even though we say in the book that at times Brennan was disappointed in Marshall. As a justice, he felt that Marshall was sort of too quick to get angry and write sort of vehement dissents and not try to persuade, and that left Brennan sort of having to do more of that than perhaps if he'd had Marshall as a more willing ally. But they were good friends. They liked each other very much. Brennan and Blackman, I think, got along very well. I would say that group. I mean, he liked Earl Warren enormously, respected him enormously. There was an age difference there, which maybe made it harder for them to be genuine friends, but almost more like mentor-mentee relationship. As to an example of where something changed, the gender discrimination area that I mentioned earlier, Brennan tried first in 1973 to have the court treat gender discrimination the same way it treated race discrimination. He couldn't get a fifth vote for that. Lewis Powell wouldn't go along with him. So Brennan came back in 1976 and worked with Powell for a somewhat lesser standard of measuring gender discrimination, but one that would still bring gender discrimination under the Equal Protection Clause. So a compromise, but one that really worked and was very effective. Thank you very much.
Today at the City Club of Cleveland, we have been listening to a Friday forum featuring Professor Steve Wermiel of American University, Washington College of Law. Thank you very much for your enlightening remarks on Justice Brennan and the Supreme Court. Thank you, ladies and gentlemen. This forum is now adjourned.
For information on upcoming speakers or for podcasts of the City Club, go to cityclub.org.